Hi everyone, welcome to the webinar. I'm Christy Baglow, the Director of Statewide Training for Florida Legal Services, and I am delighted to be here today virtually with Sarah Sullivan, who is the Pro Bono Director at Three Rivers Legal Services. Sarah is just a powerhouse in the legal aid world. That was the best way I could think of to describe her. She knows about so many different interesting topics, and it's always a joy to talk with her, and it'll be great to have her training us on Guardian Advocacy today, which is a pretty unique process. And Florida is actually ahead of the curve. Quite a few states do not have any sort of process like this. So this is something we can be proud of in Florida, and I look forward to your questions during the webinar. I'll be keeping an eye on the questions as Sarah goes through the PowerPoint. This is being recorded, so if you miss any part of it or need to go back and listen to it, I will be sending out the recording after the webinar. It has been approved for 1.5 CLE credits, and we will give that information to you at the end of the webinar. And also, a reminder to vote today if you have not already in the primary election. And without further ado, I will hand it over to Sarah and launch our first poll to see who's in the audience. Welcome, Sarah. Thank you so much for doing this today.
Thank you for having me. I really appreciate it. And Christy, thank you. I know that you and I go back several years. You are also a legal aid powerhouse, and I just thank Florida Legal Services for the opportunity to talk about this today, as well as the opportunity to share the experience with you. So I appreciate it. I know that it looks like the polls are 45. Oh gosh, look, the votes are going up. This is exciting. I don't think I've never seen the poll actually happen while it's happening. So it's really great. Yeah.
There are two questions there, so don't miss the second one.
Okay. Yeah, it's funny because it's almost like I've forgotten that I'm actually supposed to be lecturing on something. So, okay. So it looks like you guys have had, it looks like almost everyone's has voted, so I appreciate
Go ahead
it.
and share.
Yeah. So legal aid attorney, mostly legal aid attorneys, and no, they have not done a case. So this is great. This is exciting stuff. And some of you have leadership positions within your organization. So, so great. It's a good mix, though, a good mix of people today. All right. Let's see. Okay, so Guardian Advocacy. Guardian Advocacy is a type of guardianship. It is, a lot of people will say guardianship when they mean guardian advocacy. And so today we're going to talk about the reasons for guardian advocacy, why it's unique. We're going to look at the law supporting guardian advocacy, alternatives. It's something that as an advocate, you always need to look at alternatives for guardian advocacy before you launch down that, that path. Trends in public policy regarding decision making. There actually have been some legislative suggestions that have not been passed or codified, but they are, I think they're coming. At least the discussion, the policy decision decision making is coming. So, and also practical rules and considerations for attorneys and litigants. I know that this is statewide, and I will tell you right now that, and I'll probably say it again further on in the presentation, this type of guardianship does not have a lot of case law interpreting the statutes, interpreting the rules of procedure. So because of that, every jurisdiction is probably going to have its nuances. It's going to have different ways that the clerks treat the case and move it through the system, as well as different ways that the judges interpret the law. So a lot of times when you're doing these cases, you just kind of have to be flexible and go with the flow. The good news is that it's not generally 99% of the time, I would say it's non-adversarial. So as long as you, you know, cross all your T's and dot all your I's and do all the, you know, paperwork prior to filing, and then, you know, after the guardian advocacy is granted, you're usually in a good place. So, but it's always good to be flexible, because every jurisdiction is going to be a little bit different, especially now in the age of COVID. All of you probably know, no matter what kind of work that you do, that COVID has thrown, I mean, we have to be flexible, right? Because we don't know how the courts, and the courts themselves don't know how they're handling all these things. So let's look a little bit at the legislative history and policy. And I do this because it's important to kind of understand how this guardian advocacy procedure, cause of action evolved. So Chapter 393 of the Florida statutes is the statute, the chapter that deals with developmental disabilities, not just with guardian advocacy, but with services, agency for persons with disabilities, different things like that. So if you look at 393.062, it kind of defines what the mission is for this particular chapter. And it talks about community-based services, enabling individuals with developmental disabilities to achieve their greatest potential. So it talks about independence, productive living, and I put this next to Olmstead, which if many of you know is a Supreme Court case that deals with persons with disabilities having a right to live in the community. It's very similar. So just realize that the force behind Chapter 393 and guardian advocacy is independence. We're going to talk a little bit about supported decision making and different things like that later on in the presentation. But that was the goal behind Chapter 393. So so the probate rules and the were incorporated by reference into Florida statutes in 1995. However, the guardian advocacy statute came after that, which is interesting because you can see where you know, the changes to the probate rules, you know, it's kind of piecemeal, and I think that's because the statute happened after the rules were created. So it's kind of like trying to fit, you know, a square peg into a round hole kind of thing. So Chapter 744 added definitions of guardian advocate in 2004 as well. And the Office of Public Guardian was formed in 2004. Now I get this a lot, where people will call who are service providers or social workers or case managers, and they'll say, I have a client who needs a guardian advocate. And I'll say, who's the guardian advocate going to be? And they say, we don't have one. And then I say, there's not a whole lot I can do, unfortunately. I wish that we could, but there just isn't a lot of resources for public guardians. There are some, I think Tampa, St. Pete, Miami, they have public guardian offices. And there is the Office of Public Guardian, you know, in Tallahassee, but those resources to provide a guardian for everyone that needs them in the state, just not available. So unfortunately, not always an option. You know, sometimes we have some agencies that provide wonderful services like that in some situations, but they're also looking at regular guardianships for the elderly. And so it's just one of those resources. If we could figure out a way to have guardian advocates, you know, that were able and capable of serving, you know, that would be fantastic. So those leaders out there, look for ways to get that done. So the requirement for attorney representation was amended back in 2008. This actually was something that I started doing guardian advocacies before this. And so when they amended this is kind of exciting for me, because being a legal aid lawyer, you know that the need is always greater than the resources. So when this started, I said, oh, this is going to be great. It's the only guardianship where you don't have to have an attorney. The problem is that it is very difficult for pro se litigants to get through the probate clerk as well as the process with the judiciary. Think of it like this: Family Court Services was created to deal with pro se litigants. It's an entire office in many courthouses. They have forms that are Supreme Court authorized. And so they have the ability to kind of be helped through the system. No such thing exists for guardian advocacy. I mean, obviously you have the clerks, and the clerks in probate are usually incredibly helpful and wonderful, but they just are not equipped to deal with pro se litigants. However, that might be a brief services issue with some of you legal aid providers that you could kind of walk them through that process. That would be really helpful. So the term intellectual disability replaced mental retardation back in 2013. Yes, 2013, that was only 7 years ago. So they have been, they're consistent with the DSM-5, and that was published in the same year, and it changes the diagnostic name to intellectual disability. Also, the Regis Little Act was passed in 2015. That was the first time there was a major statutory change to Chapter 393, as well as the dependency statute. And it basically put the onus or a duty on DCF to seek appointment of a guardian advocate for a child in care who is reaching the age of majority. Basically, it says that at 17 and a half, DCF has to start looking for a guardian advocate for a child that's in care. There's not a whole lot about enforcement of that, but I do get calls from time to time from Children's Legal Services saying, help, we need this, how do we do this, how do we get this done? So I know that it's on their radar, and they're really trying to comply with the statute. Phelan-McDermid syndrome was added in 2017 to the list of developmental disabilities. There is a list. We're going to be going through those definitions, and I know I am not up for a character in Grey's Anatomy, but we do need to know these terms. So I may mispronounce them, or I might get tongue-tied. I'm just going to warn you. But it's important to understand the different definitions of the developmental disabilities covered under the statute. For example, children who have learning disabilities, like ADHD or ADD, or maybe have some kind of other disability that's not within the statute, are not eligible for a guardian advocacy. So just be aware of that. Okay, and by the way, I have built in question slides to pause. So if you guys have questions, we will have an opportunity in a few slides for you to ask. And I have a couple of those throughout the presentation, so you don't have to wait to the end. So as promised, what is a developmental disability? So Chapter 393.06312 defines what that is. And it includes intellectual disability, which we discussed was formerly mental retardation, cerebral palsy, autism, spina bifida, Down syndrome, Phelan-McDermid syndrome, and Prader-Willi syndrome. So it also has to manifest before the age of 18. And it has to constitute a substantial handicap that can reasonably be expected to continue indefinitely. Now, remember when I said that the DSM-5 changed mental retardation and to intellectual disability? Well, also in that DSM-5, they changed autism to the autism spectrum disorder to include pervasive developmental disability of a nonspecific nature, Asperger's, other kinds of things. It put them into the spectrum. So the formal diagnosis in the DSM-5 is autism spectrum disorder, but for whatever reason, the Florida statutes just have autism. So when you are looking at ways to prove the developmental disability, just be aware of that. I have not had a case denied because somebody had PDD-NOS or something that was autism-like on the spectrum but wasn't specifically verbally, like put out there as autism. I've not had an issue with the court, but I'm just making you aware that sometimes that might come up. Spina bifida, Down syndrome, Phelan-McDermid syndrome, and Prader-Willi syndrome. So cerebral palsy a lot of times may cause an intellectual disability, but it's not required. So you could have somebody with cerebral palsy who has normal intellectual functioning or within normal limits, but they still qualify for guardian advocacy. But what you might have an issue with constitutes a substantial handicap that can reasonably be expected to continue indefinitely. I mean, it is substantial, but you may look for people with cerebral palsy that don't have an intellectual disability, that there might be a least restrictive means, and we'll talk about that in a minute. So the 2019 legislature actually considered adding another disorder called X-linked myotubular myopathy. These are fairly rare diseases, but that they were thinking about doing that. A lot of times, some of the other disabilities on the list will include an intellectual disability. For example, Down syndrome, cerebral palsy, autism, there might be a co-occurring intellectual disability. So what is an intellectual disability? It's significant sub-average general intellectual functioning. That's just like a giant word salad, right? What basically it means is that if you were to if your client or the adult disabled child were to take a IQ test, their IQ fits within a particular scale. Now, the scales for testing haven't changed significantly in a while, right? So the test is one standard deviation is 15 points, average is 100, gifted is 130. And an intellectual disability would be 69 or below. So think of it 70 to 100, 15, 2 standard deviations below 100, which is that normal. So that is how they test for an intellectual disability. They also could do other kinds of tests that deal with adaptive functioning, such as the Woodcock-Johnson scales of independent behavior and the Vineland. These tests come in and out of popularity and favor, and so it's really good to kind of understand the test that led to your client's diagnosis. Because think about it this way, they might have been tested back at age 3, age 5, age 9, and they're now 17, 18. So the tests that were used back then may still be valid, but they may not be used as much. So the Wechsler, and I'm probably butchering that, but the Wechsler is one that is used pretty standardly, as well as the Otis Lennon. So it really, I know that back in the day when I was in school, we did Otis Lennon in the school setting because it was a, bubble test. It was a fill in the bubble test. So it was easier for them to give. Also for many kids, they will test in a school setting, but some people may have to go to private psychologists to get testing for the IQ test. So cerebral palsy, a group of disabling symptoms of extended duration, damage to the developing brain that may occur before, during, or after birth, which creates a loss of impairment. So people with cerebral palsy run the gamut of having no visual symptoms to having maybe some difficulty ambulating, to being in a wheelchair, to being almost completely intellectually and physically disabled, where they're unable to communicate. So it really runs the gamut. Autism, same way, right? You might have somebody with super high IQ and has Asperger's, so they have autism characteristics with social interaction, but they may not have impairment with nonverbal communication or imaginative ability. So it really is on a spectrum. Have had some clients that have pretty significant autism and with a co-occurring intellectual disability. So they're not able to function without some significant supervision. That's why this is an opportunity for you to also kind of educate the judges. You know, there were some judges that I've appeared in front of that thought that if you had autism, there was some, I don't want to say cure, but there was some doubt in doing it without, you know, for example, waiving all the reports and everything. They didn't want to waive all the reports because they felt like there might be some growth in the abilities of somebody with autism, even though it's a developmental disability. And, you know, to this judge's credit, the maturity and the ability to learn and retain skills, you know, might be true for someone from the age of 18 to 22 or 18 to 25. So that kind of makes sense, but it also kind of applies to every other developmental disability, or all of us really for that matter. So that's just something to think of. Okay, spina bifida, there's a medical diagnosis, and usually it is at birth. It's something that is diagnosed at birth or soon thereafter. Down syndrome, it's caused by the presence of an extra chromosome 21. So Down syndrome is also one of those disorders where the person can have a significant intellectual disability that's kind of co-occurring, or could also be very highly functioning, or could have fairly good adaptive functioning and is able to live independently. So just because somebody has one of these disorders does not necessarily mean that a guardian advocacy is appropriate. They may be eligible for, you know, advanced directives or something if they're able to understand and choose someone to help them make decisions. Phelan-McDermid syndrome, it's interesting, this is the one that was just added in 2017, but one of the characteristics is developmental delay and intellectual disability. So why they felt the need to add it, I don't know. But they did, so it's there, but it includes intellectual disability. Prader-Willi syndrome also includes moderate intellectual disability. So this one, oftentimes parents may not know exactly that their child has Prader-Willi. They know they have a developmental delay, but sometimes there's an excessive drive to eat, which leads to obesity fairly early on in the child's life, and short stature, mild facial dysmorphism. So when I've had some clients come in and say, I have to lock the cabinets in the house, and that shocks people sometimes, and I have to do this because if I don't, they'll eat everything, and they have a drive to eat. It's not even like I'm hungry. It's not like having a teenager in the house. It's something that's almost obsessive. So when some of these things come up, I'll say, is it possible that it was a Prader-Willi diagnosis? And, or, you know, at least look for that. So these are things for you to be aware of. The reason we're spending so much time on definitions is because they matter. You have to have one of those disabilities listed, one of those conditions listed in Chapter 393 to be eligible. And your clients define their children's developmental disabilities very much in different ways, okay? So we're looking at it from, do they meet the statutory definition of XYZ, you know, the 7 disorders. But the parent may say, oh, they have a developmental delay, or they have a mental health condition, and you know, I had one client that had a diagnosis of autism, but when it comes down to it, we really suspect that it was a mental health disorder and intellectual disability. And so you really have to kind of, you know, suss that out, figure out what their diagnosis is, and then have proof of it. Now, Do you have to have a full-on trial about whether or not the person has a developmental disability? No. But if you're preparing for this, and if you're going to have an attorney ad litem that's appointed to represent the child, then yes, absolutely, you need to be able to prove that they have one of the diagnoses in Chapter 393. So for right now, Christy, do we have any questions from our audience?
Yes, we do. So the first one is, a Florida circuit on the West Coast has a county clerk that indicates all guardianships must be filed by an attorney. I pointed out that a guardian advocacy is not a guardianship, and each has their own statutory framework. As you know, the guardian advocacy statute specifically states that pro se filers are allowed.
Yes.
So the second part of that question is, have you encountered clerks resisting pro se filers? What have you done to better educate a clerk?
Yes, I have had that issue come up, and it really depends on who is there from a customer service perspective for the clerk at that counter when that person goes in to file. Now I don't, now it's all different with COVID, but usually what I have done is I will tell the client, if I'm just helping them do pro se forms, I'll say, you might encounter some difficulty, stay the course, you have absolute right to file, and then I'll encourage them to give me a call if they have issues. Like, call me from the clerk's office if you have an issue, tell me what's happening. And sometimes that's an opportunity, in a gentle way to educate the clerk's office on what their rights are. Now, if you have an issue with that, then I would go to the supervisor for that clerk, or the clerk for that particular issue. Sometimes court administration can be kind of a referee, even though the clerk's office and court administration are two completely separate entities. Sometimes court administration can be a really great resource to kind of help with things like that. So I say stay the course, encourage your client to do the same, have that client call you if there's an issue, and then have a chat with the clerk, and then just keep on going up the chain of command until you get someone that can be a decision maker. It may not happen that day, but just keep on going. And after you do it one or two times, they're not going to deny those people from filing.
Great, that's all the questions for now.
Okay, very good. Let's keep going. So we talked a little bit about probate rules and how they were created. Now, unlike civil or family, they don't follow chronologically the course of litigation. So understanding that makes it easier, so you're not going around, all over the probate rules. So probate is actually in Section 2, like the probate of estates, and guardianship is in Section 3. So guardianship is where you want to be for the probate rules. And I will tell you, sometimes the probate rules read like legislation, and sometimes the legislation reads like a rule. So you just have to accept that and read them together. Just because the term guardian advocate isn't in a particular rule does not mean that it doesn't apply. And I'm going to give you an example. All guardians, including guardian advocates, are required to complete an oath and designation. The oath basically is the guardian advocate swearing and affirming that they're going to be a good guardian advocate. And the designation of resident agent is think of it as kind of like a corporate designation, right? It's somebody that can get served in the event that you skip town. That's kind of how I explain it. It's not a very it's an inelegant way, but it usually gets the point across. And that's a very simplified requirement for designation. So why do they not have every form of guardianship listed in Rule 5.600 or other similar rules? The statutory references and the rule refers to 393.12. even though the statute doesn't refer to an oath. And 393.12 says the appointment of a guardian must be conducted according to the procedures of 744 and Florida probate rules. So my intention is not to make your head explode, but you have to take chapter 393, chapter 744, and the Florida probate rules and read them all together in order to make sure that you have everything that you need to file your guardian advocacy. Best practice is to read them all together as one body of law and make sure you're meeting the requirements. And we're going to talk about some ways to kind of do that easily without having to sit there with, you know, all of your, you know, Westlaw up on your screen or anything else. There are ways, there are forms out there, there are all kinds of things that are going to help you figure all this stuff out. So we talked a little bit about the necessity, people that might be higher functioning that would not necessarily need a full guardian advocacy. And so I want to kind of do a sidebar on advanced directives and durable powers of attorney. So there is a statutory requirement that the court determines if there's any advanced directives or durable power of attorney prior to awarding a guardian advocacy, okay? So you ask, why would someone even have these if they have a developmental disability? There might be some people that have a developmental disability, for example, Asperger's, a form of autism. You know, they might have Down syndrome, but have an IQ of 70 or so, that have the ability to understand what they're signing. Now, I personally, this is my personal practice tip, or yeah, I don't know, boundary maybe is a better way of saying it, but the durable power of attorney requirements in Florida have powers and superpowers and things that people have to initial and sign, and it has every kind of financial product and document that you could possibly imagine under the sun in the durable power of attorney form. Now, you know, lay people understanding that is difficult. So explaining that to a person that has the ability to say, I want that person to help me make medical decisions, you know, that's one thing, but the financial powers are kind of complicated. So a lot of times it may be appropriate to have them do an advanced healthcare directive. Also, living will, you have to explain the 3 conditions and have the person sign off on that. And, you know, discussing end-of-life decisions may be difficult for somebody with a developmental disability, but they may have the ability to say, I want my mom or my dad or my aunt or my uncle or my caregiver to help make healthcare decisions for me. So that might be a valuable tool, and the court is required to ask whether those exist, and they're also required before they sign off on that order granting the guardian advocacy if there are any other least restrictive ways of accomplishing the goal of supported decision making. So just to be aware of that. You will have some clients that come in that really don't want to take away any powers you know, away from their child. They just want that. Somebody told them they needed it, or they want to be able to make decisions in their adulthood. A lot of times people will, they'll maybe not do it when they turn 18, but they will wait until that adult disabled child has a medical issue, has to go to a specialist they've never seen before, and then the specialist says, oh, by the way, mom or dad, you can't be in the room because you don't have the authority, or you can't make this decision because you don't have the medical authority. And technically they are true. That's true. That's a true statement. So for example, the parents don't perceive, because they know that they have a child with a developmental disability diagnosis. They know what the limits are on their child, and they just think everybody else knows, right? And that when they turn 18, they continue making decisions because that's what they have to do to care for their loved one. But in the eyes of the law, and this is how I usually explain it to clients, in the eyes of the law, once that person turns 18 years old, they're their disability was their minority in the eyes of the law, not their disability. So, or their developmental disability. So once they turn the age of 18, they have legal rights and responsibilities just like any other person turning 18. And so explaining that to the client is really important for them to understand why it's important for them to do it, and why it's important for them to do it really closer to their 18th birthday, 17 years, 6 months, you know, whenever. I also get some clients that are super on the ball, and they come to me when their kid's like 13, 14, 15 years old. It used to be that there really wasn't anything clear that said when you would file this. I mean, you wouldn't really need it if you're the natural guardian by statute until the child turned 18, but there's some situations where children are living with aunts and uncles and other caregivers. So there might have been a reason where it was important to have it prior to age 18, but now there's a statutory, when they changed it with the Regis Little legislation, they basically said 17 and a half is when you can file. So practice tip, we kind of already discussed it, but the durable power of attorney and advanced directives is an appropriate discussion to have as an initial case analysis. Just because somebody was told they needed a guardian advocacy or guardianship doesn't mean it is the least restrictive. And also just a little chat about decision making. Hospitals like to have guardianships or advanced healthcare directives or some kind of legal document that tells them what kind of medical care can or cannot, or is not consented to. However, there is a statute which gives basically gives a list of people that can be decision makers absent a guardian advocacy or guardianship or advanced healthcare directive. And so just realize that there are other options out there. Now, if you have someone that really is vulnerable and can't make decisions for themselves, is guardian advocacy a good option? Absolutely. And it's less restrictive than a full guardianship. It's more restrictive than advanced healthcare directives, but remember, the person with a disability is the one signing the document saying that they understand. So it's important. Guardian advocacy is a tool, but it's not the only tool in your toolbox. And you need to really, from a professionalism standpoint, from a malpractice standpoint, have a full discussion with your client about all the different least restrictive and more restrictive options. So I had a client to come in. She was one of my favorite clients. I think I represented her several times over the course of maybe 10 years, 15 years. Had a child that really cerebral palsy, significant intellectual disability, could not ambulate independently, needed help with everything, every daily living activity. And she came in and she said, I want a full guardianship. And I said, well, that requires you to file an incapacity petition as well as, and I'm not sure it's least restrictive because her disabilities really kind of, the origin of those are developmental in nature. And she felt like a full guardianship was more protective. And then she had a adult daughter who she wanted to be the standby guardian. But she was out of state. Now, with a regular guardianship, you can be an out-of-state guardian if you're a family member. With a guardian advocacy, this is where they actually differ, and it's in Chapter 393. You have to be a resident of the state of Florida. And so we had this, we went round and round because, you know, I was willing to do it. I told her, I said, if we file a full guardianship, it's quite possible that the judge will say that it's not least restrictive, and we'll have to either amend or refile. Or if we do a guardian advocacy, they may say that there's a problem because your daughter lives out of state and can't be a standby because under the statute she doesn't qualify. So I don't even remember. I think we actually went for the full guardianship and it was granted and the judge didn't ask any questions. And the client looked at me like, I thought this was going to be an issue. And so, you know, it really just, like I said, this is one of the situations where it depends. who your judge is or who, where you are, what jurisdiction you're in. But so in that particular case, the daughter was made the standby guardian. It was a full guardianship. Incapacity wasn't really an issue, but arguably she could have, the attorney ad litem or somebody could have intervened and said, this isn't the least restrictive, you can do a guardian advocacy. So I like giving examples because for me, when I'm practicing, having an example kind of makes things more concrete for me. So let's talk a little bit about the process. And so we've already talked about the statutes and the rules that apply. The main structure of the process is found in Chapter 393.12. 393.12 subsection 2 establishes the cause of action. And then the rest of that section establishes what must be in the petition, how and who should be noticed, the necessity of an attorney ad litem, and the standards for what is covered or considered at the hearing to appoint the guardian advocate. Now, another difference that I'm going to point out between guardian advocacy and guardianship. In a guardianship, you have two lawsuits that are filed, the petition for incapacity and the petition to appoint the guardian. So the incapacity is whether or not the person needs a guardianship, and the petition to appoint is who is the person that's most suited. They have two separate case numbers. One is in the mental health division, the other one is in the probate division, but they kind of go through the court process together, but they're two separate entities, or two separate lawsuits. So the attorney ad litem in a straight up guardianship is appointed in the petition for incapacity. Now, a guardian advocacy, what makes it awesome for people with developmental disabilities, think about the whole Independence Olmstead theme, is that there is no petition for incapacity. So there is no finding. I mean, there can be, but generally there isn't. Guardian advocacy does not require a finding of incapacity. So that's awesome, right? Because that's less restrictive than guardianship. But where do you appoint the attorney ad litem? So in Chapter 393, it basically says that the person with a developmental disability has the right to the appointment of an attorney ad litem. So, so that is where an attorney ad litem is required. Now, all guardian proceedings and incapacity hearings are required to be recorded either by electronic means or stenography, and each jurisdiction differs. I know in where I practice, it's usually, well, it depends on which county, but usually it's a recording. The judge hits it during the, when we're all making introductions. But some, for example, may have a court-connected stenographer. However, if you've never filed and you don't know how it's being recorded, definitely ask the judicial assistant or the clerk how that's handled, because you would hate to get to a final hearing and realize that it was your responsibility as the attorney to get the stenographer. Okay, so that's where one of those jurisdictional kind of quirky things might pop up. So another interesting note, 393.12 requires a standard of clear and convincing evidence, which is a really high standard. The existence of a developmental disability is rarely contested. So remember, we talked about how you want to have all of your proof and you want to know specifically what the disability is, be able to communicate it to the attorney ad litem doing their investigation. The reason that's important is because it's always important to be able to prove what you're trying to prove, but the standard is clear and convincing evidence, which is a fairly high burden of proof. So that's why you have all of your, your IEPs, your evaluations, your medical records. I'm not saying you have to spend hours and hours of time and hundreds of dollars proving this. Your parent, who's going to be the guardian advocate, if they're suited to be the guardian advocate, is going to have all this information or will know how to get it. That's also a good way to screen your clients. If they don't know any medical information about your client, but they want to be guardian, run for the hills, because that's not necessarily the person that you want taking care of this vulnerable adult. Okay, so the process for real, like this is really what happens, okay? So a lot of the stuff is the paperwork ahead of time. There's a bunch of stuff you have to file. a bunch of different forms. It is different from a dissolution of marriage or a, it's different in that, or a civil case where there's one pleading, right? One petition. Now there's a whole bunch of stuff you have to have. So the petition to appoint the guardian advocate. Now, discussion of person or of person and property. It really depends, right? I like if I'm if this person is going to be represented by me, doing the person and property. I think that if you do it over property as a pro se litigant, you might be stopped at the clerk's door, because I think the statute kind of says that if it's over person only, then pro se litigant can do it. But if it's over person and property, they might have difficulty. Is it possible that's going to slip through the clerk? Maybe, but it's not necessarily accurate. So the forms that you can find, which we'll talk about that in a few slides, but mostly are over person. Now, if you do it over person, you don't have all these, accountings and all these different kind of financial requirements. You don't even have to worry about trying to petition to waive them. Here is my concern, because a lot of times Social Security needs a guardianship or a guardian advocate, right? They need some kind of guardianship paperwork, power of attorney or a medical proxy or a healthcare surrogate form does not work with them. Now, if you are the representative payee, you have certain powers to do things. But what happens if you need to appeal? What happens if you need to do all these other kinds of things? And that's when there's actually Social Security has some rulings, internal rulings that basically say they, in order to really talk to the decision maker, you need to have a guardianship. So that's a big reason why people do this. Now, Social Security, it's a public benefit, which kind of would be over person. What if it's something that has to do with, for example, their Social Security being in a bank account and being commingled with funds, and you need to do something to, let's say that they were, I don't know, something with a credit card. Technically, if it's only over person, I'm not sure you could deal with that. So that's why I do like the whole shebang if I can, person and property. I also try to waive all of the annual reports, but that can always happen. So after you do the petition to appoint the guardian advocate, which basically says, this is a person with a developmental disability that needs help with decision making, and this is why, then that guardian advocate does an application. Now, the application is the same application that you do for a regular guardianship. There's nothing magical about it. It asks you a bunch of questions about your education and, do you have any disabilities, mental health or physically? Do you have any special training? They make sure that you follow those requirements in Chapter 744, like there's no court finding of child abuse and neglect. They haven't been convicted of welfare fraud, that kind of stuff. So there's a list in 744 of all the kind of things you can't be a convicted felon, even if it was 50 years ago. If you are a convicted felon, it is a non-starter. And that's where a lot of our indigent clients have issues, because they might have a felony conviction, even if they didn't serve time. Let's say that they entered into a plea agreement and they have an adjudication of guilt for a felony. That is a no-go. You cannot be a guardian advocate in that situation. So a lot of times what I try to do is look at, if it's a parent that has this, I look at either the other parent, an adult sibling, an aunt, an uncle, somebody that's close that can have the authority but still take the feedback from the parent that's actually doing the caregiving, that's the convicted felon. So it is always a good idea to file the application to determine civil indigency, to waive the filing fee and other fees. Also, if you do that, the attorney ad litem usually comes from either a list that the clerk keeps or from the Office of Regional Counsel, where I practice. It's Office of Regional Counsel, and I get the same attorney ad litem over and over again. So we've become friends and colleagues and kind of know what to expect from one another and have a trust relationship with one another, which is great. because sometimes things happen and it's nice to have somebody on the other side that isn't gonna rake you over the coals. So, anyway, so the indigency, you draft it with the disabled person's income and property. It's interesting because the instructions don't really say that, but you can get the civil indigency granted because usually the disabled person who, you know, who's the subject of the guardian advocacy doesn't have any assets, but the parents may. So, you know, that's just a kind of a practice tip, is that you don't fill it out as the person that's petitioning to become the guardian advocate. You do it as the ward, and then you at the bottom of it are signing as the petitioner, parent, affiant to that person's assets and debts and all the other stuff. So petition to waive criminal background and credit check. In my jurisdiction, the interpretation is that if it's a guardian advocacy, the criminal background and credit check requirement in 744 doesn't apply. I don't know. I'm not going to say they're wrong. If they say, hey, you need to go get it, I'm going to do it. So this is one of those situations where it really does differ from circuit to circuit. The requirements are found in Florida Statute 744. There is no case law interpreting what this means. I think it means for GAs over person and property, but may apply to over person only. I don't know. It just hasn't been interpreted, so you just kind of have to find out. But you can petition to waive, and it's really important to waive those things if you've got a family member that doesn't have a criminal background, has decent credit, hasn't filed a bankruptcy, that kind of stuff, because it just, you don't have to pay for it, you don't have to go through it, it doesn't slow down the process. It's just one of those things that makes it a much smoother transition. Optional with initial filing, petition to waive requirements, not just criminal background and credit check, but bond. That's an important thing to waive. Family members don't generally need it, but it's good to ask to have it waived. Educational requirements. For guardian advocacy in our circuit, the judges only make them do like half of it. So it's not like a full-on 8-hour thing on a Saturday. But you know, that's a different thing from circuit to circuit. If I have a client that is, you know, all in the business of the person that they're taking care of, like they know their finances, they know all of their benefits, they work with their support coordinator, they know what they're doing, they don't need to go to this educational, you know, this class, this 8-hour class. Some of them may want to, but I like to tell them, you know, tell the court you don't need to, but if you want to sign up for it, you go for it. You know, it's up to you, but you don't want to necessarily be forced to and then be, you know, possibly in contempt if you don't complete it in time. Annual plan or accounting. Ugh. Annual reports. Guardianships last forever until the ward regains capacity or passes away. And if you're dealing with somebody that's just turning 18, they have a long life ahead of them. So if there is any way that you can get the annual plan or accounting waived, do it. Ask for it. The worst thing that the judge could say is no. And you might get it waived, which is awesome. A lot of times these are parents that have been taking care of the kids that just need the authority to continue caring for them, continue making medical decisions, continue working with Social Security, you know, continue working with the Agency for Persons with Disabilities. So there's so many other people that are in their daily lives monitoring what's happening. There isn't necessarily a need for an annual plan or accounting. Also the oath and designation, which we kind of talked about before. By statute, you have to file it before the letters are issued. Usually letters are issued at the final hearing. So it's good to have that. It just, you know, makes sense to file it when you file everything else with the initial petition. So once the petition is filed, the attorney ad litem must be appointed by the court. We kind of already talked about that. It's Office of Criminal Conflict and Civil Regional Counsel if the person's indigent. And if that office is not available, then they take it usually from a list that the clerk keeps. So by statute, the court is to set a date for the petition. But But like I said, this varies from jurisdiction to jurisdiction. You know, some jurisdictions you file and the clerk expects you to move the case along. But if you're in a jurisdiction like where I practice, the clerk kind of just moves it along for you, which is really awesome. So you just have to know, because you could file it and expect that the clerk is gonna, you know, move it along, get the attorney ad litem appointed, you know, schedule it. You know, in our jurisdiction, they do everything, but they don't schedule it. You have to call the judge and set it. But in other jurisdictions or other counties, you know, they kind of set it for you. And so you just have to know what they do and be prepared and be flexible. Also, some jurisdictions have separate probate clerks, separate probate divisions. Others have general clerks that do everything. And guardian advocacies may not be that common, especially in the more rural counties. So just be aware that that could kind of impact how quickly and how effectively those cases are processed through the system. Okay, the hearing. So the hearing notice is sent. The attorney ad litem completes their investigation and either writes a report or presents an oral report at the hearing. Again, a jurisdictional thing. You have to notice next of kin, and that is that's by statute. The notice of hearing for this, for guardian advocacy, is different from a general notice of hearing like that you find in the rules of civil procedure or family law. So you have to, there's some extra language that goes in there that talks about the attorney ad litem and Elisor, you know, giving notice, and you have a right to, you know, have your own private attorney, you know, that kind of thing. So just be aware that it's a more involved notice of hearing. At the hearing, the court has to make specific findings, and those are statutory. So make sure the 5 subsections are included in your proposed order. This is the one and only reported case on the guardian advocacy statute. And basically, the court has to have specific findings. So if you are, and most of us are going to be the ones drafting these orders, you have to make sure that those five subsections are in there. So after the hearing, you are not done. All right, unfortunately, you are not done. Like I said, guardianships last forever. If you do a notice of limited appearance, you can kind of control that a little bit better. But after the hearing, within 60 days of the letters being signed, the guardian advocate must file an initial plan, which is social, medical, residential, and inventory, which is financial. Even if your client has nothing, even if they have no social security, they have nothing, their parent buys them everything, you have to put that in the inventory. It is a snapshot, Polaroid, whatever you want to say. It shows what they have and what they don't have. The requirement cannot be waived. So remember when I talked about waiving the annual plan and accounting, that is different from the initial plan and inventory. 2 different forms, or 4 different forms if you want to be technical. So the clerks usually require the inventory is accompanied by copies of bank accounts, Social Security award letters, those kinds of things. So you have to be able to provide that to them. You have to tell your clients, because that sometimes is the biggest bump that you're gonna, you know, speed bump that you're gonna hit, is the ability to get bank accounts. Do we have any questions? Christy?
Yes, we do. Thank you for all that good information. So the first question is, have you seen a scenario where the ward or client is in fact totally incapacitated and, if evaluated, would likely have all rights removed and a plenary guardian appointed? But instead of going through the incapacity and guardianship route, someone, usually the family, goes with the guardian advocate route to avoid the need for an attorney. Do you see that as a legitimate, least restrictive means?
I do find that it's legitimate because does that guardian advocacy order give the parent or the caregiver the power to make the decisions that they need to make. And I know that the whole goal of guardian advocacy is independence, and if you've got somebody that's just completely physically and intellectually disabled and they can't make, and they're incredibly vulnerable, right? I think that's the concern that I'm sensing from this question, guardian advocacy is still the least restrictive. I think it still has, you know, if there are concerns that this person will make wise decisions on behalf of the disabled adult, they can always do the annual plan or annual accounting and not waive it. I have had clients that I was like, ooh, you know, they're not convicted felons, but they don't make the best financial decisions. You know, we need to talk about the importance of maybe doing an accounting or maybe doing an annual plan to check in. A lot of judges will do that. They won't waive the annual plan because they want to check in with a family every year. So that's an option.
Okay, the next one is just a comment that someone has had standby guardian advocates appointed who live out of state. So maybe that varies by jurisdiction.
That does vary by jurisdiction. And like I said, I mean, I want to say that I may have had a couple of those too before I really, you know, read the statute carefully. But if you read chapter 393, it says no guardian advocates can be, they have to be residents of the state of Florida. And so a standby, I mean, are they going to move to the state of Florida? Would they become guardian advocate? I mean, maybe that's how they get away with it, is that, you know, they have that standby. But I think when they're standby, they have to say that they qualify under the statute. So that's one of those situations where there's the technicality of the statute, and then there's what happens in real life. And the fact that nobody has appealed that particular issue because everyone's just trying to take care of everybody else. It's not a super controversial statute. So if you're able to get away with it, congratulations.
So the next question is, who do you include for notice of next of kin?
So I usually include adult siblings. If they have a caregiver, like let's say they have an aunt or an uncle who have been caregivers, you know, I usually include them. And then I include bio dad, even if they've had, I mean, obviously they're next of kin, right? Even if they've had absolutely nothing to do with the child. There have been some really interesting things that have happened with me trying to serve. The client will say, the parent, the mother will say, I have no idea where dad is. Haven't talked to him, I don't know. And I'll say, okay, well, you know, we'll try. And so I'll usually try to do my own little investigation and find, you know, a person. And I have actually found the wrong person. And that causes a lot of, what? I had a kid? What? You know, you're 18? So be careful with that. It may be worth it for you to get a private investigator to do like a skip trace or skip search. To find someone. I will tell you, the Westlaw People Finder isn't always 100% accurate, or Lexis. So, you know, it could cause some, I had one guy that was incarcerated, and he had a common name, so I got the wrong guy. And so then he started harassing my client, like, hey, what's up? You know, like, hey, do I know you? So just be careful with that. It can actually be, you know, but you do have to notice the biological father or biological parent, even if it's like a mom that hasn't been, you know, a part of the child's life, went off somewhere, you still have to notify them.
Okay. Can a guardian advocacy be filed for a person who suffered a stroke and can no longer make decisions?
No, because the diagnosis, unless the stroke was before the age of 18 and caused an intellectual disability that is able to be diagnosed with one of the diagnostic tools. So I'm assuming that it's an adult that maybe had a stroke and can't make decisions now. That has to be a straight up guardianship. You know, but if it was like a child that the stroke caused an intellectual disability and they're able to prove that with a diagnostic test, like, you know, the WISC or the, you know, one of the other tools, then maybe, but generally no.
Okay, and can the guardian be undocumented?
Yes. Do I need to go into that?
Nowadays, yes, I think so.
Okay, so they have people that are undocumented or without papers have every right to access the civil system, and you can be very, there's no requirement for you to be a citizen or a lawful permanent resident in order to be, there's no requirement in the statute for that. And a lot of times you will have a child that may be a citizen or a lawful permanent resident, but the parent is out of status. But that does not prohibit them, and they should be encouraged to have decision-making authority for their child, because it will just further complicate their entanglement with different systems as they get older. So I encourage them to do the Guardian Advocacy. Do courts ask the question? Yes. And it is recorded, right? So you have to be honest about it. But I know that I've had courts that have not necessarily asked straight out what the status is, but we'll put on the record that the granting of a guardian advocacy does not confer any citizenship rights or status or provide any, they want to have that in the order, and that's fine. I'm not sure the federal government really cares what the state court says, but so that might happen. But it is not a straight out requirement. So just like any other kind of civil cause of action, the whether or not you are documented or without paper or in status doesn't matter.
Okay, that's good news. One more question just came in. If indigent, is the Guardian course free?
I believe it is free, or is at a reduced rate, but I'm pretty sure it's free. But that is one of the things where it's provided by different entities. The clerk of court would know who those entities are, because they sometimes do the follow-up and the referral. But it's always good before you go to court to call and find out what, if they're used to dealing with indigency affidavits. But I've never had a client came back and said that they couldn't afford it or they had to pay.
Okay, apparently it's not free in Orange County. So
okay, see, jurisdictionally, it's a weird jurisdictional thing. Is there a reduced rate in Orange County?
I'll wait on that.
I don't know. Well, yeah. I always like to know what these weird little idiosyncrasies are. It's weird. Like where I am, it's totally free, and they only have to do half a day if it's guardian advocacy. But I've heard other jurisdictions where it's the full shebang, the whole 8 hours.
There is no reduced rate. So thank you for letting everyone know that. We also had a compliment come through. Great job, Sarah. Do you have forms for all of these documents you mentioned?
Ooh, well, right after we get done here, I'm going to show you all the little hacks on the forms and things that we have. So yeah, we'll be talking about forms, and I will tell you that Orange County Ninth Circuit, they're rock stars. They've got fabulous forms. They don't have a lot of AI where they're not super interactive, but they have them in like 5 or 6 different languages. Which can be very helpful if you've got a client that is a non-English speaker or English as a second language. So anyway, if anything else, we'll hop right into all that useful stuff.
That's it.
Okay, great. So we kind of had a discussion of over person and over property before we took questions. And like I said, I've always been an advocate for asking for both when I'm an attorney asking for it, because I feel, why not ask for everything that you can possibly ask for that covers every possible scenario in the future. And I think I gave the example of dealing with Social Security or dealing with a bank account. If it's over person, it's arguable that you don't have the power to do that. So I've had the court question me on that, like, why do you want it over property if the only asset is the word Social Security income? And I tell them, because you never know when there's going to be an issue that, kind of goes from over the person to over the property type stuff. Things to think about: identity theft, Social Security appeals, and overpayments, which may impact bank accounts, bills, debts, future income from employment. Yes, a lot of people with guardian advocacy may have a job. They may have supported employment through their Medicaid waiver. They may have, they may work at ARC and make, a few dollars here and there. They may have a job, a full-time job at Publix. Who knows? So it's a very diverse and wonderful population of people. So over property might be necessary. Disadvantages of over property. If the annual accounting is not waived, that is a bear. You know, talking about somebody that avoids math at all costs, that's me. I don't like doing that. Your clients are going to like it even less unless they're accountants themselves. But so that it does require an attorney. And I told you before, the language is squishy about whether or not you have to have an attorney at all to file a guardian advocacy over property. And I gave you the statutory in the PowerPoint here. It's 393.12 subsection 2B and 393.12 subsection 10. Criminal background check and credit check is required if it is over property. Like I said, I don't know, my jurisdiction just hasn't really required it. At the beginning, when that statute was passed, I would go and file a petition to waive, and then the judge kind of looked at me like, why are you doing this? I don't require him for guardian advocacy. I was like, all right. If you want to look more carefully at over person versus over property, it is addressed in the Guardian Advocacy Statute in Chapter 393. It's 393.12, subsection 2B. So limited representation. This is super important for pro bono attorneys. For legal, it's important for everybody, because if you don't want to be on the hook of representing somebody forever, it's important for you to do limited rep. Now, limited rep does not necessarily mean that you abandon them after the final hearing when they're appointed. Usually what I do is I put something in there that says after the 60-day initial plan and inventory, and then I'm out. Some clients are, the guardians themselves are vulnerable enough that you might want to keep it open, but that is between you and your litigation director or your managing attorney or your supervisor, because it is a commitment. So how do you file a limited representative? There actually is a probate rule specific to this, okay? 5.030B. So you can file a limited appearance, and it has to be a specific kind of notice, specifically limiting the attorney's appearance, and then after, and you have to file it at the time that you file everything initially. Whether or not you can get away with filing it later, technically it's not correct doing it that way. You have to do it at the beginning of litigation. How do you, and I think it's also a good idea not just to have the notice of limited appearance filed with the petition, but to have some kind of limited representation retainer that is an addendum to whatever retainer you use in your office. Very much so, be very specific about the characterization of your representation if you're doing limited rep. So how do you terminate it? It terminates upon the attorney filing this is what it's called, a notice of completion of limited appearance. And you have to serve a copy on the client and other interested persons, which probably would be the attorney ad litem, the ward, maybe the next of kin biodata, I don't know. Otherwise, the Florida probate rule applies, okay? So an attorney of record may withdraw or limit the attorney's appearance with approval of the court after filing a motion. So why go through the whole thing of filing a motion and having to have a hearing, even if it's by Zoom or whatever it is these days? Why do that when you can negotiate that at the beginning of your attorney-client relationship, explain to them a limited rep, explain to them what that means, what will happen after the initial plan and inventory are filed and accepted by the clerk, and what your client's obligations are going to be. Now, some people may come back and reapply for services if you work for a legal aid or legal services corporation, and that's fine. But some managing attorneys may not want you to necessarily be on the hook for every year doing this. Or maybe they'll say, hey, you need to, because these are people that we serve. And so really that's something that you need to talk about, not only with your supervisor, but also with the client so that they understand. But pro bono attorneys, when I am assigning these now to pro bono attorneys, I tell them, I said, please do limited representation. Here are the forms. Here's how you do it. Please do this, because the last thing you want to do as a pro bono coordinator is have the attorney say, why am I still on this case a year later, 2 years, 5 years, get me off of it. So I try to do that on the front end when I'm recruiting them. And usually it's a great recruiting tool, right? Like, hey, you can do limited appearance in this. So once you're done, you're done. You can use it. For those of you that are coordinators out there, you can use that as kind of a hook. So forms, this is that question. So there are no Supreme Court authorized forms. There has been discussion. I think that there's a probate work group that's working on them. I don't think they're done, but they are working on it. So stay tuned for that. Many jurisdictions have taken it upon it themselves to create their own guardian advocacy forms. I want to see Tampa. There's, I think Orange County was the first, and they're the most robust in their offerings in different languages and different things. The FLOSSY forms, which those of you that do probate and wills and things like that, those forms are available for a price. I think Westlaw has them, but they come off when you try to print them. I think they say sample or something, so you have to kind of, unless you pay for that service. You can see what the verbiage is, but you might have to type it yourself. So the first and the best, I think, jurisdiction for forms is the Ninth Circuit. Tampa has them. Let's see, other forms may have them. Now, I'm very excited about turning18.org. Turning18.org was a website that was created by Florida Justice Technology Center. It is now, I believe, under the supervision of the foundation, the Florida Bar Foundation. And I use turning18.org when I'm doing brief service clinics as the pro bono coordinator. I use it when I'm doing brief service myself as an attorney. I use it when I'm doing pro bono. I encourage pro bono attorneys to utilize it. It is fantastic. And I say it's fantastic because it does have a certain level of artificial intelligence, so you're not having to interpret what the form is asking you for. Whereas the Ninth Circuit has nice forms where you can, type or handwrite or drop down where you can put in the answer. You have to kind of understand what they're asking for. Whereas turning18.org asks the person as if they're a pro se everyday, person, where do you live? What county? So you don't have to say, well, what circuit? Who knows what circuit if you're not an attorney? That kind of stuff where it asks you, questions that are fairly easy. And then at the end of the experience, it assembles the form based on your answers. So it's really, really great in document assembly, but is not created for attorneys as much as it is for pro se litigants. But it's perfect as a tool in pro bono advocacy, as well as, I just had an initial screening and I just used it with the client because it gave me all the information I needed, and it took me about an hour and a half. But now, if I prefer to use my forms that I like, I just say, here's all the forms that were generated. Let's take that information and adapt it to, whatever, attorney form that I like to use. So turning18.org is fantastic. It's a great tool. It also is not just about doing guardian advocacy. By the way, it's guardian advocacy over the person. I think they ask if it's over person or property, but I think it was really geared and created towards over the person, guardian advocacy. It provides great information for somebody that is unsure about what they want to do or doesn't know, or somebody just said, hey, go do this. It's a great way to tell your client, go read up on it, because it prompts a bunch of questions. It tells you about least restrictive means, alternate independent decision making. It's just really a great resource. So I encourage you, while it's still around, and I think it should be and will be around, for the foreseeable future, definitely check it out and look at how it can be used, as a tool to do that. Also, talk about pro se, litigants. They can get all their forms done, and it even has a little thing at the end that asks you, that basically tells you if there's any little special quirky forms that the clerk may use. Which is fantastic, because you might avoid some of those hiccups that pro se litigants have when they try to access the courts on their own. Oops, it's going to the Ninth Circuit. Well, that's what it looks like. And it has all of, if you see Chinese, Creole, Portuguese, Russian, Spanish, Vietnamese. I didn't mean to click on the link, but I did, so you can kind of see how it's all done. And then they actually have a kind of a supervisory little document that kind of tells you what everything is, but pretty impressive. They have all these languages. I think that's pretty awesome. So I'm going to try to get back to my, there we go. Okay. And turning18.org, I'll just show you that while we're doing this. So see, and it says get started. It's pretty easy. It has all these different things. And so it's pretty user-friendly. So Carrie raised her hand. Does she have a question? Carrie Bowden? While I'm figuring out how to get back to my PowerPoint.
Just going to hop in and let you know that we're not seeing the links you're clicking on, so that's good.
Oh no! Well, hopefully we'll have a way to get them the PowerPoint where the links will be active. So I'm not sure why that happened because I shared my screen. So that's totally weird.
And I will be sharing the PowerPoint and the recording with everyone. It should be in your email tomorrow.
Okay, so you can go have some fun, go crazy looking for forms because I have a few links there. Okay, so we kind of have already talked about this all along the way, and I know we have only about 10 minutes left, but statutory idiosyncrasies, there's tons of them. You know, there's weird little nuances that haven't, either there were drafting errors, but that, you know, they don't make a big enough deal. It's not impacting people's access. So differences between guardian advocacy and guardianship. We already discussed that the court does not order incapacity in a guardian advocacy. Now here's what's weird. Chapter 393 discusses incapacity and discusses removal of rights from the ward. But this isn't cleared by any case law. There's no case law interpreting it. And the whole idea of a guardian advocacy is that you don't take away incapacity, right? You don't incapacitate the adult. You don't remove rights and, you know, give them to somebody else, give them to the guardian. So it's kind of this weird, you know, hey, we're giving the guardian advocate powers, but we're not removing them from the ward. And they don't even call it ward. They call it a person with developmental disability. And all the paperwork, it shouldn't say ward. Sometimes we abbreviate it because it's easier to say ward than person with a developmental disability, but they're not a ward. The petitioner must be a resident of the state. We kind of talked about that. Not a requirement for regular guardianship. But that's in 393.12, subsection 3. Someone is able to get away with that in some jurisdictions, so good for you. Like I said, you know, I think with a standby, they just have to understand there's this kind of weird quirkiness in the law, and they may either have to terminate the guardianship or transfer it to another state, or do that whole, you know, you're going to have to look at your kind of recusal, you know, fair faith, full faith and credit type weird stuff. You know, that might be an issue, and sometimes that's more complicated than it's worth. So guardian advocacy versus guardianship, that's one of the discussions you have to have if you've got an out-of-state standby. I've had actually, you know, I had a standby that was relatively young. It was an adult brother, but I want to say he was in his early 20s, and the judge basically said, you know, this person has a long road ahead of them, and so it's very possible that they won't be qualified by the time they become the guardian. So in that particular situation, you know, just also tell them they don't just automatically become the standby guardian, right? They might have to file another application. They may have to go through that criminal background check. They may have to do all those things that a regular guardian would do when they apply. So this is something weird, which I had to read the statute over and over again, and I'm a super geek. So this is my interpretation of it. A petitioner need not be the actual guardian advocate. All right, that sounds weird, right? The petitioner doesn't have to be the actual guardian advocate. If you, and that's important for Chapter 39, because if you think about it, the department could be the petitioner, but the applicant could be somebody else. I actually did one of these in a rural county, and I'm not sure if they said, oh yeah, you were right, Sarah Sullivan, or if they just didn't understand. You know, the client was actually an agency, and or I want to say it was like it was somebody that was a caregiver, but that was more of an institutional caregiver, and the guardian advocate was like a professional guardian advocate. So So anyway, that could create some, I mean, we're getting kind of really into the details here, but technically the petitioner does not have to be the actual guardian advocate. The applicant would be the guardian advocate. The Regis Little Act to protect children with special needs requires some pretty burdensome requirements on the dependency court and not a lot of enforcement clarification in that statute. So DCF is required to seek a guardian advocacy for a developmentally disabled child in the state's care. So not in a permanent guardianship, not in a relative placement, not in a, state's care at 17 years, 6 months. So, and they're codified in Chapter 39 and Chapter 393. Now, I say not in a permanent guardianship or not in a relative care. I mean, technically, I think they're in the state's care until the court removes jurisdiction, right? For those of you juvenile experts out there, I'll let you kind of play with that. But can you imagine if DCF had to find a guardian advocate for every child with a developmental disability in the state's care? I mean, that's a lot of kids potentially that have IQs that are below 69. That may have autism, that may have spina bifida, all I mean, just think about it. I think it's a sizable amount of kids that they are now required to seek a guardian advocate for. And there are not enough I mean, if they don't have enough people to have permanent placements for these children, how are they going to find guardian advocates for them? That's my point. That's my criticism. I think it's great. I think everybody that needs a guardian advocate should have them. But I just can't imagine that there are enough eligible guardian advocates out there that can take this stuff on. So prior to the 2015 changes, the Regis Little Act, we kind of discussed this before, there was no age requirement. So I've had situations where the caregiver has been a non-relative or like a, not a next of kin necessarily, but a interested person or relative caregiver, and they needed it before the age of 18 to deal with Social Security or something else. So that was a reason to do it. But now, since 2015, it's pretty much the 17 years, 6 months. So parents usually are kind of advised by the school district that they need to start looking at that. A lot of parents will come after the 18th birthday. That's fine. They don't turn into a pumpkin if they don't have it by the age of 18. I have had parents with a 40-year-old Down syndrome child who never needed it until their child started aging and having health issues, and then started running into problems with specialists. And so they were in their 70s as the client, and got a guardian advocacy just so that they could make healthcare decisions for their son. So they had successfully navigated life without a guardian advocacy for, I mean, gosh, when he turned the age of majority, this cause of action didn't even exist. So, so it happens, and it's okay. Like I said, they're not gonna come take your 18-year-old once they turn 18 if you don't have a guardian advocacy. School likes it, medical providers like it, and they like it because it gives them guidelines on who the decision makers are. Support for disabled adult children. So this is where we're kind of getting into our policy discussion about things to look for in the future. I've had, because I've done enough of these, I've had kind of these weird situations where maybe there was a support order when the child was a minor and it never got extended. Or I had a situation where the dad was kind of paying under the table, not through child support enforcement. And, he took care of the kid. And so she just kind of let it go. Child turns 18. She kind of figures he's going to continue paying support, and he decides he's not going to. That child's 18. There's no cause of action. So the family law section of the Florida Bar identified a gap in the law concerning adult disabled children. Now, there has since been a case, I believe it's Fernandez, and I can provide it to Christy, that basically says that even a child that is an adult can sue for support beyond their 18th birthday. So I think it's coming. It kind of codifies that concept that if you have an adult disabled child, that you should, and let's say you go through a dissolution of marriage after their majority, or there's one of these other kind of weird circumstances where there's not an active support order. If that is in the child's best interest, the adult child's best interest, no less, and you look at all the factors, then there should be a cause of action, either in family court or in guardianship court, for support for that child. And really, there wasn't a clear path or a clear cause of action for that. So it's one thing, right? If the ward, let's say it's an adult guardianship for an elderly person, they may have a pot of money and they need to pay things monthly, that the guardian has the ability to access that. But in a support situation, it's someone else paying that support. So this provides that cause of action. Let's see. So if you want to look at it, it's Senate Bill 1648 and House Bill 965. The bill was drafted over, I don't know, 7 or 8 years. It took forever. And, was vetted by all the different other sections, reptiles, public interest, everybody else. And then they found sponsorship for it. It died in committee, but we have a feeling that it's probably going to come up again. A lot of times it happens with proposed bills, is that you have to kind of do them year after year until you get them passed. But I think this is something to look forward to. Okay, and I know that we're right at 1:30, so I'm almost done. Another proposed bill was supported decision making. I don't think they had a sponsor for this, but it's a movement of individuals looking for legislative changes to kind of create another advanced directive. And this is Disability Rights Florida has this kind of cone of decision making, with self-determination being the ideal at the top, and then going down to court-imposed guardianships. So it's possible this issue is going to come up in the 2021 legislative session. They have like a sample directive that the group that's proposing this, it's a supported decision agreement. It's very similar. Think of it this way, it kind of does this decision making by taking all the technical language out of the healthcare stuff and the financial stuff. It kind of makes a separate agreement that would be probably more appropriate for a person with a developmental disability. Let's see, other than that, any more questions?
We do have some questions.
You guys are asking great questions, by the way. Thank you.
Yes, they are. Are you able to show the CLE slide while we do questions?
Oh, yeah.
Get that. Do we have to file an accounting if the only income is Social Security?
That would be a guardian advocacy over person only. And the answer is no. You just have to, you probably want to make sure that order appointing guardian advocate is over person only, and then you don't need to do, if you have it over property, that's what triggers the requirement. But I believe the statute says if the income, or it's the rule, I don't remember if it's the rule or the statute, but if it's only over person, you don't have to do that accounting.
Okay, great. I know you covered this, but it's worth repeating. Do you have to wait for the ward to turn 18, or can you file before so that it is in place when they turn 18?
I think at 17 years, 6 months, it's fair game, you can file. But can you do it at 15? No. You used to be able to, but usually you had to give a pretty good justification for while you were doing that. I had a situation where there was a mom, dad wasn't in the picture, child was setting a lot of fires and getting involved with criminal stuff, and the mom just felt like it was better for her to have decision-making authority through a guardian advocacy. And so we kind of explained that to the court, and the court said, all right, now we wouldn't, after the Regis Little, the 2015 legislative change, it really is kind of concretely 17 years, 6 months. But like I said, if they don't file by the time they're 18, other than the parent not having the legal ability to really make decisions, no one's gonna question that.
Okay. And we just had a comment from Palm Beach County. They put the discharge of attorney for Guardian Advocacy and Regional Counsel in the order. That way they're both off the case at the end.
Ooh, that is awesome. Yeah, that's a great practice tip. I might actually borrow that if I do this presentation again and plop it right in there. But yeah, no, that's a great. And I know that in my jurisdiction at the hearing, the attorney ad litem asked for discharge as kind of like the last thing that he does, but he usually doesn't get out until the initial plan and inventory are filed. So what he does is he asks for that prayer for relief, kind of, or a tennis motion, and then once those things are filed, the order gets signed by the judge. So there's a lot, there's more than one way to get it done, but I really like the idea of putting that in the final order. That's great. Good tip.
All right, and we had several people have some questions and comments about the Regis Little Act, asking if it applies to, does the Regis Little Act apply to foster care when the child stays with the foster family after turning 18?
So the obligation is on the department to look for a guardian advocate at 17 years, 6 months. So from a legal perspective, the foster parent after the child turned 18 would not have the ability to make legal decisions. But because there's extended foster care and all that is an interesting legal question for people that really are doing a lot of juvenile law, is whether or not an extended foster care, like a formal foster care situation, not just like, hey, I'm staying with this family, whether or not that would confer the ability of that foster parent to make decisions absent a guardian advocacy. Does that make sense? Did I answer that person? That's a good question.
I think so. And there was a comment from Dade County with Regis Little, although you can initiate at 17 and a half, we aren't able to have the final hearing until age 18.
That makes sense.
Have you been successful with having a final hearing before age 18?
I have not had that issue come up because usually the parents are coming to me at 18 plus, or we hit that 18-year benchmark before the final hearing. So, but I believe that's consistent with the statute and the rule regarding the person has to be 18. Otherwise, I know it in the juvenile situation you have the state is kind of the parent, but in most cases, the natural guardian has the ability to make decisions up until 18. So that's consistent with, I think, a public policy.
Okay, that's it for questions, unless anyone has any last minute questions, but I just want to thank you so much, Sarah, for taking the time to do this. That was such a thorough explanation of the background behind it, how to do it, practice tips. It was wonderful. And I really appreciate you and Three Rivers Legal Services allowing us to share this with a statewide audience. Thank you so much.
Yeah, thank you, everyone. And I appreciate your feedback or questions you have after today. I put my contact information on the last slide with the CLE. So if you think I got something wrong, or if you just want to talk about a situation or what your jurisdiction's doing, please call me, because I really just I feel passionately about people being able to care for their disabled adult children. So we're kind of all in this together, and as kind of a safety net for people. So thank you for letting me do this, letting me chat for the last hour and a half. I really appreciate it. And good luck to everyone, and be well.
Thank you. Bye-bye.
Bye. Thanks.